And we're live.
All right, thank you, Jamie, and good morning to everybody that's logged in and members of the council. This is our December 3rd meeting of the Juvenile Justice Reform Council. Welcome, and Jamie, if you could please call the roll.
Sorry, just getting set up here. Secretary Abed.
Present.
Senator Smith. Senator Carter. Senator West.
Present.
Delegate Clippinger. Delegate Jackson. Delegate Pippy.
Present.
Sorry, Delegate Jackson is present.
Secretary Green. Ms. Tolentino.
I'm here.
Mr. Kemmerer. Ms. Egan.
Present.
Judge Stamm.
Present.
Ms. Douglas. I saw Ms. Douglas in the room.
I'm sorry, I'm present.
Dr. Gilbaugh.
Here. Morning, everyone.
Dr. Lawson.
Present.
Dr. Sickman.
I'm here.
Mr. Bayless.
Present.
Deputy Commissioner Sullivan.
Present.
Mr. Schellenberger.
Good morning, all.
Ms. Davis.
Good morning, present.
Ms. Mandel.
Good morning, present.
Mr. Dodson. Ms. Handy. Mr. Campbell.
Present.
Ms. Chapman.
Good morning, President.
Mr. Fonseca.
Present.
We have Jessica Wheeler standing in for Mr. Fuston today.
Good morning, I'm here.
Ms. Johnston.
Good morning, I'm here.
Mr. Ford.
Present.
And Deputy Secretary McGlone.
Good morning, I'm here.
And that's the roll, Mr. Secretary.
All right, thank you. And in the package that Jamie sent out to you yesterday were included minutes from the last meeting. If everybody could take a moment, if you haven't already, and review those, and we'll take a motion to approve. Or before we do that, if there are any corrections, we'll take those up first.
I didn't notice any need for correction, so I would make a motion to approve.
I would
Seconded.
second that motion.
All right, any opposed to the minutes? All right, we will take those as passed and move into the meat of the agenda here, which is some presentations, I believe, excuse me, starting with Selena Cuevas on diversion.
Yes, good morning, everyone. Let me just share my screen. Okay. All right, so this morning we are talking about diversion opportunities and services in the community for youth in Maryland. So there are various ways in which diversion can take place in Maryland. 3 of the ways that it can take place before a case reaches the courts is through local police departments. Some police departments may have diversion programs for young people who have been arrested, such as Baltimore City, who diverts about 10% of young people arrested each year through this program. Youth can also be diverted through DJS, excluding felony cases and handgun violations, which Anton will talk a little bit more about in his presentation. DJS intake officer can divert cases by resolving the case at intake or through informal pre-court supervision. And then there's the state's attorney's office. So for cases that do result in an authorized formal petition, the state's attorney's office can deny, withdraw, or send the petition back to DJS. And for the purposes of this presentation, we're focusing on diversion through DJS. And so to provide some context about DJS case forwarding decisions over time. So as we've talked about, complaints have decreased by more than half from 2010 to 2019. The percentage of cases that are resolved at intake has actually increased over the past 5 years from 29% to 45%, while the percentage of cases resulting in pre-court supervision has remained pretty stable over time, between 16 and 17% over the past few years. So exploring cases that are resolved at intake, like I mentioned in the previous slide. So overall, about 45% of cases in 2019 were resolved at intake. And looking at which young people have the highest percentage of cases resolved at intake, we see that it's girls, that it's white youth, that it's young people from Central, Eastern Shore, and Southern regions. And then of course, young people coming in on these more lower level offenses. When breaking down cases resolved at intake, in terms of charge severity and looking at differences across race and ethnicity, you see that for the most part, Black and white youth have pretty similar rates of cases resolved at intake, while Hispanic, Latinx, or other youth have lower percentages resolved at intake. Then for cases resulting in pre-court supervision, again, this is a smaller percentage of cases that result in pre-court supervision, about 17% overall. Girls, white youth, and Hispanic Latinx youth have higher rates, as well as young people from Metro and Western regions, of cases resulting in pre-court supervision. And again, these lower level offenses as well. And here the pattern is a little different when you explore differences by charge severity and race and ethnicity. You see that Black youth actually have the lowest percentage of cases resulting in pre-court supervision across all charge severity categories. And so now exploring differences in diversion from Baltimore City and the rest of Maryland. So as you'll see on figure 1, this top figure on the right-hand corner, only about 22% of cases in Baltimore City were diverted in 2018 in comparison to 58% of cases for the rest of Maryland. This can partially be explained by the fact that Baltimore City has a much larger percentage of more serious offenses in comparison to the rest of Maryland. However, as you see on figure 2, even for misdemeanors, a larger percentage results in a formal petition in Baltimore City in comparison to the rest of Maryland, which may have to do with a different booking process in Baltimore in comparison to in other regions. So now focusing specifically on pre-court supervision and what we know about it in terms of completion. So the percent of young people who successfully complete pre-court supervision has remained pretty stable over time at about 80%. And for the young people who have cases that unsuccessfully complete pre-court supervision, between 35 and 40% of those cases are then forwarded to the state's attorney's office. As for recidivism outcomes, the recidivism rate for young people on pre-court supervision within 1 year after the complaint decision date is 9%, which is lower than young people whose case results in a formal referral, where the recidivism rate is 15%, but slightly higher than cases resolved at intake, where the recidivism rate is 7%. DJS doesn't have a whole lot of data currently tying recidivism to specific services received, but what we do know from outcomes of MST and FFT is that about 10% of young people who complete these programs are adjudicated delinquent or convicted within 12 months after completing. So 90% are not. And then looking at how services vary by region. So at intake, young people are screened by an intake decision tool in order to determine their needs and best connect them to appropriate services in the community. These services can range from mental health, family focus, education, employment, mentorship, and they also vary across region in terms of the number of programs available. So what the data shows is that the most programs are available in Central and Eastern Shore regions, with Metro having the lowest number of programs available, and that the most common services offered overall tend to be mental health, family focus, and those focus on substance use disorders. And so the main takeaways from this presentation is that while complaints have decreased, the percentage of cases resolved at intake has increased, while those resulting in pre-court supervision has remained pretty stable over time. The young people with the largest percentage of cases diverted are girls, white youth, and young people with less serious alleged charges, and that all regions except for Baltimore City divert over half of their cases either through resolving it at intake or pre-court supervision. On average, about 80% of young people successfully complete pre-court supervision, and about 90% of those who complete pre-court supervision are not re-adjudicated or reconvicted within a 12-month follow-up period. And that while the number of programs available to young people in the community varies by region, the most common services provided focus on mental health, family dynamics, and substance use disorders. And that's all from my presentation.
All right. Thanks, Dr. Cuevas, for the presentation on the data here in Maryland. Anton, you're going to give us a presentation next on diversion practices and an overview of the national practices. Or do we want to have questions for Selena before we move?
I have a technical question. I'm wondering if I could ask. Can you just the diversion by DJS intake and pre-court supervision are like mutually exclusive categories in this? Can you explain what they mean and how they differ and how DJS sees them in terms of sort of severity of is pre-court supervision in between diversion and formal petition? Is it a status in there? Can you just explain the difference between them?
Yeah, so I can explain it how I understand it, and DJS can jump in. So resolving at intake takes place when furthering the case would be against the best interests of the child, whereas pre-court supervision seems to be a level more serious, where there's this contract that young people and their families and DJS kind of reach, where the young person has to complete some conditions in order to keep their case out of the court system. I don't know if anyone wants to add to that or correct that.
It's Betsy. I think you did a great job explaining it. And just to be clear, though, it's a post-arrest, post-sort of charging intervention. So resolve would be sort of your first step, where maybe it's a first time, really low level offense. And then pre-court supervision is a little bit more intensive, where we do provide some services, some interventions, and work with the youth for a period of time.
I have a question.
Go ahead, Dr. Sickman.
For the set that are resolved at intake, does that exclude cases that were just dismissed because there wasn't sufficient evidence to proceed?
Well, Betsy, if you want to answer, but no, a dismissed case would be one that had already been forwarded and dismissed by the court. So these are all efforts that we take prior to forwarding the case. So we can put a youth, we can divert a youth, as they said, with pre-court supervision, but that doesn't mean their case ever goes forward to trial. It could, but this is at a previous step.
Okay, just clarifying. The key factors into the decision for the resolved at intake versus the pre-court supervision, is that like need of the child and the family, or sort of what's the?
I don't want to be too casual about it, but a case like underage possession of alcohol, somebody comes in, they had beer at a party and they shouldn't have, we'll meet with the parents and they'll have taken, some action on their child, grounded them, no car or something. And, there really isn't anything needed to go further. We don't need to supervise that child. We can resolve that case at intake. If there's a need to supervise a kid, so for instance, we might have somebody that has a behavioral health or a substance use issue, to make sure that they're getting those services, we can do the pre-court supervision. And if they follow through with those services, that would be the end of it. So that's sort of the difference. I don't know that it's so, finely tuned towards the charge as much as it is about what we need to do in order to resolve the case.
Okay. And
we also use a risk screening. So I think we do look at risk. So we use a risk screening tool. We have a structured decision tool that helps us make that decision if a case should be resolved, or if a case should be pre-courted, or if we should go forward to court. Additionally, that's it for now.
The other question that I had was, I know this presentation focused on the stuff that sort of comes to DJS, but the police diversion appeared to be all post-arrest diversion. And do you know how the fact of an arrest, does that factor into the risk assessments and those type of things? Because I know that, and maybe Anton will be getting to it in his presentation, other jurisdictions have come up with mechanisms to avoid that arrest staying on a kid's record, to divert pre-arrest, deflect.
So I think there's sort of a few questions there. One, arrest does not factor into the risk score when we make our decision at intake, but complaints would, but not arrest. If a case does not come to the Department of Juvenile Services and there is a post-arrest or pre-arrest diversion conducted by law enforcement, then there would be nothing on the young person's juvenile court record related to that incident. And the juvenile code does sort of contemplate that law enforcement would use diversion in certain circumstances, and allows police to do diversion for a period of time. And then if that diversion sort of doesn't perfect, then they can forward it still to the Department of Juvenile Services. But we do see sort of, we don't have really a consistent approach as it relates to law enforcement diversion around the state. Some localities have really robust programs, others don't have any. So there's a pretty large continuum when you think about what police diversion looks like in the state.
Okay, so it seems like most of the diversion still has strings attached, where the kid, if something doesn't happen, they can come back in on that charge.
Unless it's resolved, and we resolve a large portion of the cases that do come to our attention for lots of reasons. A young person may already be involved in a program. The school, if it's a school issue, the school may have already made a response. So there's multiple issues that go into a resolved case. And just because a case is resolved doesn't mean we can't refer the young person to something that the family may need.
Thank you.
Can I ask a question? The one that bubbles to the top for me is the fact that Baltimore City is so anomalous compared to the rest of the state. The rest of the state's numbers consistently seem to diverge from Baltimore City, and I can't understand the reason why. It may be that there are fewer diversion programs in Baltimore City that are available. Maybe a recommendation we could make is that the city be more resourceful, or the state help the city be more resourceful in terms of developing programs that would work in Baltimore City. I'm not sure that the explanation offered that the crimes in Baltimore City are violent, therefore fewer diversions. Does that really explain the entire magnitude of the disparity between the city and the rest of the state?
Well, I believe Dr. Cuevas's presentation did mention that, but also that there were different practices in the city. And Betsy is very engaged with those city practices. I don't want to keep calling on you, Betsy, to answer the questions, but there are different practices that are, that take place in the city that we do think have some contribution. You want to take it, Betsy?
All right, so there's a few things that probably contribute to the differences in Baltimore City related to the rest of the state. We forward a lot higher percentage of cases in Baltimore City, as the presentation sort of showed. But part of that is because we at DJS cannot pre-court use our diversion practices for felonies. We have to work with the state's attorneys to do that. So we do have sort of a smaller percentage of misdemeanor offenses coming to the attention of the department in Baltimore City than we do other places, which reduces that ability to use diversion practices in Baltimore City. Charging looks different than it does in Baltimore City. Most counties in the state utilize paper charging or paper charging documents. So for example, if a law enforcement officer has contact with a young person, it's a lower level offense, the young person gets taken home or their parents come and pick them up. And then later, we evaluate that, do an assessment, we may resolve pre-court or forward that case to court. In Baltimore City, most complaints are going to come to our attention through arrest and then bringing the young person to the juvenile booking center with a detention request. So there's this really sort of contraction of lower level offenses that reduces that ability for us to be able to act with diversion practices.
I'm just going to interject and add under the consent decree for the Baltimore Police Department, the city of Baltimore commissioned a study by the Center for Children's Law and Policy, which put out a very in-depth report about the problems of diversion in Baltimore City. They were careful to note that the differences in charges does not account for the difference. In fact, when we look at drug crimes, there are much higher diversion rates outside of Baltimore City than there are in Baltimore City. So it's just not the level of crime. Even the more serious things are diverted elsewhere and not Baltimore. And there is a large working group. They're meeting this morning. I'm missing that meeting to be here to work on those diversion issues. But I just wanted to note that is not the full explanation, as Senator West noted. And two, the slide that Dr. Cuevas showed is that there are much less services in Baltimore City and the metro region, which are the two most populous regions of kids, which is quite concerning. I will say there has been no multi-systemic therapy option or provider in Baltimore City for almost 5 years, and no one providing family functional therapy for almost 5 years. And those are services that are available almost everywhere else in the state.
So, Doctor, this is Scott Schellenberger. I don't want to put words in your mouth, but I mean, it seems like this part is working. I mean, that was one of the better sets of numbers that we've seen this entire time. I mean, did you reach any conclusions about this other than our discussion about Baltimore City and their different practices, the diversion and that informal intake process and things kind of seems to be working. Do you feel that way?
I just want to confirm that you're talking to me when you say doctor.
Yes. I'm sorry.
Oh,
I thought
mean, yeah.
I just gave you a promotion.
No, I am, but there are multiple doctors on this call that have spoken up. So I do think that the numbers here look better than what we've seen in other presentations. I do think that there is room for improvement in terms of pre-court supervision numbers and in terms of programs that are offered to young people. I do know that DJS is going to roll out a newer, better data system on services where you can tie it to recidivism and maybe get better answers for some of these questions. But it does seem that young people are doing really well when they do complete pre-court supervision. It's just a matter of making it an option for more youth, I think, is what one of my main takeaways was.
Thank you so much.
All right, any other questions or comments before we move to Anton's presentation? All right, Anton, you're up.
Mr. Chair, could we please have a copy of the PowerPoint emailed to us?
Sure. I thought it was emailed with the package that was sent yesterday, but if you didn't get it, Jamie, please make sure that you email a copy to Chairman Clippinger.
Thank you.
Sure. I think I need to follow up with Jay Johnston and Andrew Trust to get a copy.
Okay, we'll get that out, and if it didn't go out to everybody, we'll send it to everybody as well. Thank you for pointing that out. Any other questions? All right, Anton, you're up.
All right. Share my screen. All right. Okay. Can everyone see the screen, the slides? All right. Good morning. I am, of course, Anton Robinson, working with Vera. Today I'm going to be talking about recent, and I'm putting an asterisk in the word recent because there is some other interesting legislation, maybe not so recent, but I thought it was relevant to bring up in this conversation as we think of improving diversion outcomes for young people in Maryland. This is principally a conversation about how other jurisdictions, other areas are increasing access to diversion. And I'll also say that thank you for that conversation about Baltimore City, because you did some of the heavy lifting for me, everyone, so I appreciate it. To review how diversion works in Maryland, when a youth is brought to intake today, the intake officer may propose informal adjustment or diversion so long as the youth is not charged with a felony or a gun charge. And so in those cases, where the charge is a felony or a gun charge, then they have to hand over the case to the state's attorney immediately and with all of the case information. And then from there, the prosecutor will determine whether it's in the best interest of the public and in the best interest of the child. They'll determine how to proceed with that case. So whether they file a petition, refer the complaint to DJS, back to DJS for informal disposition, or to even dismiss the complaint. And so throughout this presentation, we'll be talking about some of the legislative measures that other jurisdictions have taken, Florida and California. I lumped those together because we're going to be looking at, for those two states, the pre-arrest diversion, And then for the others, we'll look at a more traditional diversion. So Kentucky, Kansas, South Dakota, and Utah. And there are some other states, and maybe that'll come up in our conversations, that are doing work on this issue right now. But these states seem to cover the broad sort of idea, the big idea of what these other states are doing and what is available. And so starting with pre-arrest diversion, it prevents youth from being formally processed by the juvenile or criminal court systems. And so it generally occurs when police officers choose not to arrest a young person, or even when schools decline to involve police officers, period. And throughout the country, you see two major types, one being a caution and warning program, and another being civil citation programs. And so the caution and warning programs will be more like what you see in Maryland. It's where the youth receive a warning or a formal caution instead of further justice system processing. The caution programs generally occur pre-charge and are led by police officers. Traditional caution programs typically involve the youth, their parents, and a police officer who describe the consequences of further delinquent behavior. So quite literally, in those programs, no matter the degree of formality, it is a conversation with the young person with an explanation of the circumstances of their behavior. In more, I guess, a bit more formalized iteration of this idea, some states have implemented civil citation programs. And those programs allow youth to avoid arrest by accepting citations for misdemeanor offenses. As a condition of accepting the citations and avoiding arrest, the youth may be required to complete community service hours, participate in intervention services like counseling, and also be subject to other sanctions like restitution or filing or drafting apology letters to the complainants in the case. Generally, the programs have seemed to work. So compared to traditional system processing, police-initiated diversion programs modestly reduced delinquent behavior among low-risk youth, but there were no significant differences found across the different types of programs. And I raise that because there's this suggestion, it doesn't mean that programming is a bad thing. It just means that we should maybe look into how beneficial warnings really can be, particularly for young people. And then the information at the bottom is from Sykesville. That is their variant of the caution program. And it essentially allows the officers to determine whether services are available to the young person or whether to divert the young person in certain circumstances. And they consider the nature of the charge, the age, of course, of the person, and the availability of community-based programs and other resources. And so that's why that bit about the availability of programming and whether there's any available keeps coming back. And provided that there were, it could be a better option for diversion. I'll note that, and I think it was Ms. Egan who referenced the Baltimore City program. I believe also in that report that one of the recommendations was simply encouragement that officers could use some infrastructure as to how to divert young people and encouragement to divert young people. And then in terms of getting the young people to the Baltimore City Juvenile Justice Center, that maybe there are some different models of making the referral for diversion programming. Maybe there's a call-in method, things of that nature. So continuing on with the pre-arrest diversion program, I just want to reference Florida's civil citation program. It's the longest running police-initiated civil citation program, dates back to 1990, and is currently present in 60 of the 67 counties in Florida. The interesting thing there is that prior to 2011, it was sort of ad hoc in a way, but Florida passed legislation to make it more available in different areas. Their program is for young people charged with misdemeanors, and they qualify so long as they are, it's not a misdemeanor involving a firearm or a sex offense, and there's no indication of gang activity. But when Florida passed the legislation in 2011 to essentially encourage different jurisdictions to use the civil citation program, the law that resulted from that made it clear that the different areas had to outline the misdemeanor offenses that qualify for participation, the other eligibility criteria for the program, the implementation and operation plan, as well as program requirements. And so once they did that, there was an improvement. So they did see more programs pop up around the state. But in terms of other things that they saw, in a 2017 study, it was found that diversion programs in Florida had a 9% recidivism rate on average, like generally, and compared to the recidivism rates for the civil citation programs, where there was a 4% recidivism rate on average. And so it showed that the civil citation program was doing markedly better than the other programming or diversion programs that were in the city. In California, same thing, pre-arrest diversion. But what they did was they recently, in 2019, passed legislation. There was a monetary, I guess, buy-in amount or appropriation amount of about $10 million. But they created local county pilot offices of youth development and diversion. So kind of like a hub for diversion in 5 different counties. And it essentially sought to create a coordinated interagency collaboration to manage youth diversion programs and fund community-based services as alternatives to arrest and incarceration to divert youth away from the justice system. And so not a lot of evidence on those programs yet. I will note that one, and this is in the LA Times, one thing that has resulted is the community perceives, or there's the suggestion that the community perceives these programs to be solely related with the LAPD. And maybe they're not seeing more of the back end interagency coordination. And there's some community doubt about the intent of the LAPD. So I raise that because maybe there's a way to sort of think about collaboration in a broader way and making sure that the messaging is clear about that. So now I want to move on and talk about diversion more in the context that Selena referenced it. And I'll reference first Kentucky. They passed a bill in 2012 that requires the administrative office of the courts, so kind of like the operation arm of the judiciary. Their program requires that the administrative office of the courts refer youth to intake for diversion for first-time misdemeanor complaints. And so that's a mandatory referral for misdemeanors, first-time misdemeanors. It allows diversion even under, even if if the kid is charged with a first-time felony. And that's when the county attorney provides written approval and the charge does not involve sex or weapons. The impact so far has been pretty good. You see on the screen that between 2014 and 2018, diversion agreements increased from 45% to 58%. that nearly 9 out of 10 of youth completed diversion, and that there's been no significant impact on public safety. And when I say that, 92% of the youth diverted for public offenses, and 79% diverted for status offenses had completed their agreements. And that is actually slightly up from 91% and 77% in 2014. And so it at the very least shows that nothing negative is coming from referring a few more kids to diversion programs. Kansas, very similar language in their 2016 bill. The youth shall be offered the opportunity to participate in an immediate intervention program and avoid prosecution if the youth is charged with the misdemeanor, if the charge is not a sex crime, and if there are no prior adjudications. The other thing that Kansas did of note was they put limits on the terms of of diversion. So they limited the duration of it, so it can no longer be no longer than 6 months, where there was previously no indication as to how long diversion could go. They did include measures to keep some, betters over the child to make sure that they provide services if there's an evidence-based need for services or substance abuse treatment. They also allow young people to complete diversion early if they satisfy the conditions of diversion. And then they, as I said, allow diversion to be extended if necessary. In South Dakota, the reforms made diversion the presumptive default, so that where the youth is charged with a misdemeanor, where the youth has no prior adjudications, the youth has no informal adjudications in the past 12 months, and the charges do not allege violence or the use of force against another. So in those circumstances, the case will go straight to diversion. There are additional safeguards. They also, South Dakota, that is, also reduced the time for the length of diversion. So it brought it from what was previously 6 months down to 4 months. It includes a community services intervention model. So a coordinated effort with the Department of Social Services and the Department of Juvenile Justice to ensure that the services being offered are appropriate and beneficial. And then they also added language in 2018 to clarify their intent that while it's presumptive, diversion is presumptive for those charged with misdemeanors, it can be used in other circumstances, and that that the state's attorney's office should consider young people for diversion. And it made it very clear that that was the intent, to get more young people to diversion. So far, from 2014 to 2018, the number of youth in placements under the Department of Corrections has declined by 66%. The number of new commitments also declined, dropping by almost 63% between 2014 and 2018. And so there's the indication that diversion was once rare in the state, but has been used increasingly. And then the last state that I want to reference is Utah. In 2017. It required or passed legislation where intake officials shall offer non-judicial adjustment where the youth is referred for an offense that is a misdemeanor, infraction, or a status offense, has no more than 3 prior adjudications, and has no more than 3 prior unsuccessful non-judicial adjustment attempts. It also made clear that that the department may withhold diversion if a youth is high risk or charged with driving under the influence, reckless endangerment, negligent homicide, sexual battery, or possession of a dangerous weapon. The reason I included this, and there's not a lot, 2017 is when it passed, not a lot on the outcomes yet, but it was one model that included risk. And so on the next slide, I have some context about how that might look. As you can imagine, because that was new to the state, there are tons of different flow charts and different ways to think about it. But I like to go down to that line where the three bubbles are all blue. Just references, the question is whether a youth can be required to receive a non-judicial adjustment. And you'll see that if the charge is a status offense, infraction, or misdemeanor that is not specifically excluded, like the ones I referenced during the last slide, and so long as the youth is low or moderate risk on the risk assessment, then yes, that person is required to receive or at least be offered non-judicial adjustment. But if the charge is a certain class A misdemeanor offense and the youth is a moderate risk, then it's still an option. And then same thing in that last category. So we're back to the left over here, where it's optional for any misdemeanor, status offense, or infraction, and the youth is high risk on the risk assessment, or for any felony. So it still makes it very clear that it will go to the prosecutor and that there's still some goal for the prosecutor to review the circumstances to determine whether diversion is appropriate. And so I'll stop there. I'll note some of the best practices, both referenced just now and some of the ones I've been reading this stuff for months and months and months. You all have been doing it for years and years and years. So, but some of the best practices that I've come across include to quickly divert young people, do that as quickly as possible, mandatory referral of low-level charges, as we saw earlier in the slides, guide prosecuting attorneys to consider diversion. So even in those cases where it's not mandatory, maybe there are some statutes that include language that would guide prosecutors to review every case for diversion. You can limit prosecutor ability to override diversion decisions. You can also use evidence-based practices and infrastructure to monitor diversion programs, and even set parameters on diversion duration. And then one thing that came to me from our conversation earlier today is something that we've all talked about and is important, but cultural competency to ensure that those programs that are implemented and that are raised include cultural competency and really harken upon adolescent development. That is the idea that more programming being available, more officers and more DJJ or DJS staff will be using them. So that is all that I have from what I've seen around the country. And I open it up for discussion.
Thank you, Anton. Any comments or questions for Anton? Okay, I'm not seeing any. Thank you for the presentation, Anton. And you'll see next in the agenda that we have Anton again presenting youth charged as adults policy. And so let me just pause for a moment and indicate that this is a policy presentation. And unlike the last presentations that we saw on diversion, where we had both a sort of policy and a data presentation, we don't have the data presentation for youth charged as adults. And that's not for lack of trying, both from DLS and from us and Vera. We are still receiving data. I believe some additional data was received this morning, but there is still yet additional outstanding data. So what we decided to do was to do the policy presentation and indicate to you that it's very possible that we'll have that data and be able to do a data presentation at the next meeting, but that is sort of a narrowing hope at this point. And given the fact that we still have to do a report and vote on a report, which we need to reserve that final meeting to do, the next meeting would then have to encompass the presentation on data, the discussion on the policy, recommendations, and adoption of recommendations, which I think is going to be a bit too much to ask. So we are going to do the policy presentation, and we are still going to pursue that data presentation. And even if it is too late, our intention is to present it to you either as in a meeting, or just to present the data to you in a document at a minimum, so that at least we will have that full data set and analysis, so that folks can do something with it moving forward, even if we can't formally make a recommendation on it. But that's where we stand. And if there's any comments before Anton starts with the policy presentation or questions about that, I'll take those now.
I would say that one recommendation that we could probably write right now is that there should be data. There should be information sharing across juvenile and adult court to your agency, so that you have data in hand and don't have to beg for it.
Yes, and I think, and Ms. Egan, I'll get to you in just a moment. Unfortunately, Glenn Fuston is not here today, but we did speak, and I'm hoping that we can come together for him to forward a recommendation for us to consider on how to actually do this moving forward. Because as you point out, I mean, we can get that data set, and that'll be a good snapshot of what's going on. But in order to really implement any kind of reforms, we have to have an ongoing data stream that we can monitor, so we can see if any of the recommendations that are adopted are effective. So that is key, and I would like to try to get to a recommendation at least on that, because it is important to have that information. Ms. Egan.
Yeah, just so for the members of the council who are less familiar, GOCAP does put out information on youth charges as adults twice a year. It doesn't gather all the information we would need to do an in-depth analysis or data, but there is some data available. And what I would love to do, if next meeting potentially we could ask the technical assistance provider to list the kinds of data that they are not collecting and reporting out that would be helpful, so that we could ask potentially to amend that legislation, which isn't that many years old, that started collecting some of that data. I know that I have a list of data points that's not included in those reports that we would like to see, that would help with our analysis.
So I'm seeing Selena nodding, so I think that's not going to be a problem, and then she can report out on those issues that she has encountered in the data. All right, so that's the status on youth charges as adults, and with that, if there are no other questions, we'll go ahead and have Anton give this presentation on the policy.
Okay, I'm gonna share again.
See, Anton, I gave you about 30 seconds to get a drink of water between your presentations.
Appreciate it. All right, there we go. Can everyone see my slides? Good to go? All right, so hello again.
And we're sort of seeing your presenter view.
Okay, let's see if I can. There we go. Did that?
Now we've got your background.
Huh.
Although it's good to know somebody else's desktop looks like mine. Appreciate it.
All right, let's see.
Perfect.
There we go. All right. All right, so youth charged as adults, that's something that you all have ranked very, very highly as a priority for our work here today and throughout the time that we've spent together. as we just referenced, we'll do the data portion of this conversation at a later date. But let's jump right in and talk a little bit about what this looks like in Maryland. So first I want to talk about jurisdiction, since unlike most adult criminal court matters, jurisdiction can be used as a way to bring young people into or out of the criminal court system. Maryland's juvenile courts have jurisdiction over young people under 18 years of age charged with delinquent acts. And that's consistent with the laws of many states as well. But there are statutory exclusions. So you'll see young people or those 14 years charged with the act punishable life. Example, or driving offenses for young people older than 16 years old. You have another group for the young people 16 years old and older charged with specific serious crimes referenced in the statute. And so I'm talking about armed carjacking, page 239 of the Data Resource Guide, and also Appendix S, which references the full list. It's about 32 charges on that list of exclusions. So I'll let you take a look at that on your own. All right, so what are the pathways then to adult court? Outside of adult courts having original jurisdiction because of the child's age or because of specific charges are excluded from juvenile court jurisdiction, another pathway to adult court is waiver. So where the case starts out in juvenile court, but is sent to criminal court. Maryland has a discretionary waiver statute. Juvenile court may waive exclusive jurisdiction for youths over 15 years old for any alleged offense, or for youths not yet 15 years old, but alleged to have committed a crime punishable by life imprisonment. But the court must first determine that the child is unfit for juvenile rehabilitative measures. Another provision in the code that may lead the child to adult court is that which says if the child has been previously convicted of an adult or as an adult for a felony, and they are alleged to have committed another felony. In those cases, the Maryland juvenile courts do not have original jurisdiction, but note that the case could still be transferred to juvenile court. So some of you might be asking, like, why are young people being prosecuted as adults at all? We all accept that young people are different, that they aren't mature. For those of you who have spent any time with teenagers or other children, and maybe you recall when you were a teenager, you know that young people don't process information or react to things in the same way that adults might. And that's okay, because young people are still growing and their brains are changing. So research tells us that our brains continue to develop well into our 20s, up to about the age of 25. So quite literally, some of those behaviors that are a challenge, they'll grow out of them. The adolescence brings about changes in the limbic system, so that set of structures in the brain that deal with emotions and memory. And the result is that children are more sensitive to rewards, to threats, and even to peer pressure. But in addition to that, their cortical region is, and that's the portion of the brain that allows us to control our behavior. The cortical region is still developing, so self-regulation is much harder. I think in one of our presentations, we used the analogy that it's like having the accelerator without the brakes, right? So I think that was the analogy we used in our first presentation too. to the council. So quite literally, young people are different. Brain science tells us this, and our society is acutely aware of this, but it's also making its way to criminal courts. The Supreme Court recognized with a landmark case called Roper v. Simmons in 2005, that with it came a string of other cases that have shown that young people are different. And the case involved brain science, but it also led to the court saying a few things. It said that young people lack full autonomy. And think about it, we don't allow young people to do so many things in our society. You can't drive until a certain age, you can't buy alcohol, you can't do so many things. And a part of this is because we recognize that the second bullet, they are not mature enough to make some of those decisions. And so we don't give them a ton of responsibilities as young people. As also referenced in the case was their susceptibility to negative influences. And so those were factors referenced in that case, which, and I'm oversimplifying here, but made it so that a young person, that the death penalty was not allowed for a young person. The last bullet there wasn't as much from that case, but from a report from the Juvenile Law Center in 2020. And it referenced some of the harms that young people face when processed as adults, indicating that young people who are processed in the adult system meet elevated levels of physical assault, sexual abuse, and suicide. And so to ground the rest of the conversation, I think it's helpful to talk a little bit about the best practices. And I'm sure you all have some of your own. I've heard many of them today and in talks with many of you. But before that, I think we should acknowledge, given the brain science and social science, and that an important goal of the juvenile justice system is to consider the best interest of the child. So with that understanding, we have to treat young people in a different way. So we really have to consider the goals of our policies and whether some of the policies have primarily remained in play as a means of punishing young people, right? Particularly those charged with serious offenses. And so as we think about the goals, we have to also think about where punishment fits into the conversation. With reference to the best practices, juvenile courts should have original jurisdiction over youth for matters involving delinquent behavior. Youth should not be automatically transferred to the jurisdiction of adult court. And then juvenile court judges who are trained and equipped to assess the individual needs of young people should be the ones to make those decisions. And they have to be empowered to do that. They have to have the training and the resources to do that. So now, in talking about some of the legislative measures that some states are taking, their goal is to get closer to a juvenile justice system that does not harm young people. I want to first reference raise the age measures. Some states are taking steps to extend the upper age of juvenile court jurisdiction to include youths over 18 years old. In 2018, Vermont became the first state to treat all teenagers, so 19-year-olds included, as youth for the purposes of juvenile court jurisdiction, raise the age to 19 years old. Some exceptions, though, are for violent crimes, and it includes a 4-year implementation plan. As many of the raise the age measures do, they take a little time to be implemented, and that one is still in the process of raising the age. I'll note that California and Massachusetts both have outstanding bills. It really looks like the bills, it appears that COVID-19 and the pandemic might have had an impact on the progress of those bills. California, if the bill does pass, it would extend juvenile court jurisdiction to 19 years old and allows the court to, allows juvenile jurisdiction until the person attains 24 years old. Same thing in Massachusetts, except their goal was to raise the age to 20 years, but that 20 years old, but that bill hasn't passed either at this point. So moving on to something that is immediately important to us right now, and that's waiver. Can less youth be waived to adult court? So I want to highlight 3 states with relatively recent changes to their waiver provisions. That's California, Kansas, and New Jersey. In 2016, California repealed its waiver provisions with Prop 57. It eliminates the prosecutor's authority to direct file to adult court. So all cases now have to start out in juvenile court. And second, it requires that the juvenile court hold a hearing to determine if transfer is appropriate. In Kansas, they created a rebuttable presumption that a child's case should be heard in juvenile court. And that's, again, for all cases. And then in New Jersey, they require a written statement from the prosecutor explaining the reasons for the waiver to adult court. So these are states that sort of made big measures to keep young people in juvenile court, but there's still certainly pathways pathways to adult court if absolutely necessary. And I want to note too that for New Jersey, in the written statement that the prosecutors have to file, they require that the prosecutor include factors like the nature and circumstances of the charge, the degree of culpability, the degree of sophistication exhibited by the young person, and then whether the youth previously was referred to a treatment program and how they did in that program. Another thing that we, it dawned on me at the beginning of this week to start to think about ways that we could limit or reduce the time it takes, rather, to get to juvenile court. So if a young person starts out in adult court, can we transfer or reverse waive a young person quickly to juvenile court? And I just wanted to raise that, and these are not legislative measures that have recently passed, but I was doing a scan of the states and found that Montana's Youth Court Act requires that the hearing to determine youth court adjudication take place within 30 days of the probable cause determination. And same thing for Georgia. They also require that the petition alleging dependency to be filed within 5 days of the preliminary hearing if the young person has been removed, or 30 days if the child has been released. The idea being that where they should ultimately end up in youth court is more appropriate for them and gives the Department of Juvenile Services a better opportunity having jurisdiction over the child to determine their needs at an earlier point. And so we may continue that conversation. I don't know if anyone has thoughts on that, but I wanted to at least raise that as something that I've seen.
I have significant thoughts on that, Mr. Robinson, just so you know.
Okay, cool. I got 2 more slides and I would love to hear them.
So do I.
Okay. For the states that did not go as far as repealing statutory exclusions, there were some that that outlined by statute that the start of adult court, excuse me. Oh, I'm
Yeah, I think you still have to talk about the exclusions, limiting the exclusion. And
yeah.
then, yeah.
Cool. Sorry about that, y'all. Statutory exclusions. There were 3 states that completely repealed their statutory exclusion provisions. So one was California, another was Florida, and another was Oregon. So I know California again in this category. Of course, their Prop 57 made major changes to their system, but it did away with direct file. So now with all of the cases starting out in juvenile court, it also repealed the statutory exclusions. Florida, which has long used direct file, where the prosecutor had the opportunity to direct file charges to adult court for youth charged with serious crimes like arson, sexual battery, murder, manslaughter, burglary, the state passed a bill in 2019 which added an extra state in the process, an extra step in the process for prosecutors to direct file. So now they require due process hearings where prosecutors explain their decision to direct file the case in adult court and why it's necessary for public safety. So it acts as sort of a second look on the prosecutor's decision to direct file a case. In Oregon, in 2019, they passed a bill requiring that all youth cases start out in juvenile court, and that's true even for serious charges. What they call Measure 11 charges like robbery, attempted murder, kidnapping. Now prosecutors require a hearing and the judge decides whether the case should go to adult court. And so those are the states that repealed their statutory exclusions. There's another category of states that, while they didn't go that far, they made recent changes to narrow them, the exclusions dramatically. And so those states, Delaware, Illinois, Utah, Washington State, and South Carolina are the ones that I listed for this presentation. In 2017, Delaware passed a bill giving juvenile court judges discretion to maintain cases in youth court involving firearms, riot cases, possession of a deadly weapon, possession of a firearm while committing a felony. These charges were previously excluded, but now allow the court to bring those into juvenile jurisdiction as well. Illinois, very similar thing. They expanded the list of cases that now qualify for juvenile jurisdiction to include armed robbery and vehicular hijacking. So the legislation shifted the process from an automatic adult court case based solely on age and charge to one of due process where a hearing is required. Utah, very similar. Their bill passed in 2020 where they included aggravated robbery, aggravated sexual assault, aggravated kidnapping, and murder could be charged directly to adult court. The bill made it so that only murder, so the only one left that is eligible for original adult court jurisdiction is murder. Again, you see a trend of more serious cases being brought into juvenile court, at least for some consideration of processing through the juvenile justice system. And then same thing with Washington State in 2018, where they narrowed the list of eligible offenses, those that are eligible for exclusion, and for original adult court jurisdiction. They narrowed it to robbery in the first degree drive-by shooting, first degree burglary, and violent offenses committed while armed with a firearm. So now those charges are now eligible to, or do not rather, automatically start out in adult court. And then I end with South Carolina, and that's because they did it a little bit differently. They raised their age So they addressed the issue by raising the age of transfer eligibility from 16 to, and that's where we are right now in Maryland, to 17-year-olds. And so they didn't look at the nature of the charges, but they wondered if older children might better stay in juvenile justice court. So that is a summary of how other jurisdictions are handling the issue. And I heard that there was a lot of discussion. So I'm looking forward to hearing you, Ms. Egan, and everyone else.
So Anton, if you could take your screen down so I could see everybody else's, see everyone else's faces so I can recognize folks that want to speak. I guess we'll start with Jenny and then go Scott, and I'll take anyone else after that.
So thank you for your presentation, Anton. I greatly appreciate it. One thing that I did think was missing and that we need to ground this frame in is the racist origins of direct filing children in adult court. That the rise and the change in these statutes happened alongside and in parallel to the myths of young Black people being called super predators throughout the 80s and 90s. And that these statutes have come from racist origins around believing that young Black people were not redeemable, and the laws changed to allow and to move children to adult court throughout the 80s and 90s. We have seen, and the sociologists who propagated those lies have retracted them. But I do not want to pretend that direct file is some racially neutral policy that has always existed. The number of crimes for which children could be direct filed were greatly increased in the 80s, and then most of them were added in the 1994 crime bill, which was driven by the myths of young people being super predators. That has led to great racial disparities in the prison population in Maryland. As we saw earlier this year, we learned that Maryland's prison population is 70% Black. That's more than double the national average. We have a higher percentage of Black young people in prison, greater than Mississippi and other places that we would normally think of as greater violators of human rights than Maryland. In addition to that, there are great racial disparities in youth charged as adults. Youth charged as adults, Black youth charged as adults, Baltimore County and Baltimore City charge double the number of Black youth as adults than are reflected in their populations. So that means, what I mean to say is that there are huge racial disparities in which youth are being charged. And I would note that youth being waived up to juvenile court is highest in Baltimore County and has the greatest racial disparity. Those are huge problems, and I wanted to make sure that that frame is not lost when we talk about charging children as adults. I then wanted to just speak from some personal experience and just make it a little more intimate. Jabria Handy is on this council but not attended today. She was charged as an adult, and I hope that we would allow her at the next meeting to speak about that experience. But I personally have been affected by a young person being charged as an adult. My stepbrother was charged as an adult under a Measure 11 crime in Oregon. Their laws have changed and he would not be charged as an adult today. My stepbrother was charged for, I'll just be frank, for having sex with his girlfriend basically the week he turned 18, and she was younger than him. He was sent to an adult prison, and it has completely derailed his life. Despite the nature of his crime, the years he spent in adult prisons shaped him forever. He is imprisoned today for a probation violation that stems from the charges that he initially had. And I cannot tell you the ways in which it has devastated and destroyed my family. He has never recovered from the abuses he experienced in adult prisons when he was still a child. And neither has his mother, my stepmother, neither has his stepfather, or any of his siblings. It is, to say that children experience more abuse in adult prisons is just a dramatic understatement. The risk to kids, when they are sent to adult facilities and sentenced as adults is huge. and the risk to public safety is huge as well. The research shows overwhelmingly that charging kids as adults makes us less safe. And I just wanted to start the discussion with those two things.
Mr. Schellenberger.
Thank you. So Anton, I circulated a couple months ago a 32-page document that included some pretty horrific crimes, 44 defendants who committed some pretty horrific crimes throughout the state of Maryland. I was wondering, had you seen that document?
No.
Okay. So what I'm trying to understand is someone like Nick Browning. Nick Browning killed his father, his mother, and his two brothers with a gun, almost got away with it. I'll point out that he was white, is white, and lived in Delaney Valley, went to great schools. He killed them when he was 15. You would treat that 15-year-old murderer the same as a 15-year-old repeat shoplifter. He would be held at Hickey until I could wave him up. Is that correct?
Well, I mean, I think
Can I jump in here for a minute, Mr. Schellenberger? I just don't.
Cross-examination of Anton, and I don't want it to be perceived that way. I'm sorry, Marta. I didn't mean to.
No. I mean, I think you're saying what I was saying. This is
okay. Well, then I'll follow Miss Egan's lead, and I'll just talk about some of these cases. There was a case of Felix Fitzgerald, who was being held at the Hickey School, was committed there, and he brutally raped the school nurse there. And my point is, and I understand what Miss Egan is saying, is we are going to start with all these very horrendous crimes and defendants who committed these crimes. We're going to start them out in the juvenile court. The Hickey School is not as secure as the detention centers we have throughout the state. And so, again, as we discussed before about the amount of money we would need to have a good juvenile detention center in each county, we would have to have that in place if we were going to do this. I mean, I will circulate this document again. All I had to do was send one email out to my office and several states' attorneys' offices, and we found 44 pretty horrific crimes, which, by the way, not only do I worry about the pretrial part, but if they stay in juvenile court, then someone like Nick Browning can only be held until he's 21, which means someone who has brutally murdered 4 people would be held for only 6 years. And at the age of 21, they would be back in society. And I don't know if we've fixed him or not by then, but we would have absolutely no options. So what I'm saying is we need to be very careful here when we are talking about changing this part of the law. And I did note that there were a number of states that obviously had murder as an exclusion, but I can tell you now in Baltimore County, the reason our numbers are up is because of carjacking. Carjacking is a very personal offense. It can be a very violent offense, and it's one that unfortunately is being committed a lot of times by individuals who are 15 and 16 years old. Now, obviously, the 15-year-old starts in juvenile court. The 16-year-old can start in adult court. And again, all of these juveniles, even if they start in adult court, have the ability to waive back down. And we go through these waiver hearings all the time. The question is, where do you start? And what's the public safety issue for when you start? And Anton, I apologize. I was putting on my prosecutor hat. You did a very good presentation with numbers. And I'm done.
Dr. Sickman.
No worries.
Let me preface this by saying I work for a judges organization. So, our organization would, since the very beginning of juvenile courts in this country, there has always been a mechanism to remove kids from juvenile court and have their cases handled in criminal court. The difference is who gets to make that decision, and the statutory exclusion and the prosecutor concurrent jurisdiction, the prosecutor direct file statutes give that decision-making authority to prosecutors Waiver statutes rest it with juvenile court judges. Most states have discretionary waiver provisions. A little more than half the states have exclusion provisions, and some states also have the prosecutor discretion. The difference for the kid is when a prosecutor decides that, it's not an appealable decision. When it's in a juvenile court hearing, that can be appealed. The juvenile court judge hopefully has training and understands about adolescent development, and that decision is made on a case-by-case basis, considering all the amenability issues, et cetera, et cetera. I don't know that prosecutors have that kind of, requirements. Some statutes do. Last time we looked, I think Florida was the only place that had real formalized rules for prosecutors to follow. You're saying, oh, well, there's a reverse proceeding, so it could come back, except that tends to be that now that's a criminal court judge, and without necessarily the specific training around adolescence and adolescent development. So I would say, most states, as Jenny pointed out, made changes to their transfer provisions during the mid 80s to mid 90s period, some a little late, that made transfer easier for more kids to go. So it became more automatic. The list of offenses included being automatic was expanded. The minimum ages were lowered. And since the trend in juvenile crime, particularly violence, has declined a lot, states are rolling that back. So to summarize Anton's summary, they have gone back to having it be more of a waiver provision, making it less automatic, raising the ages, reducing the list of offenses. So that's kind of the framework that I think that we should go, is to look for places where we can pull it back a bit. Because, just think of if your kid was arrested, did something terrible and, was in this process, where would you want that child to be handled? Who would you want making the decision? And where would you want that child to serve time if they had to serve time? Frankly, unless you're going to keep the kids in for life, I would much rather have a kid get out sooner, but having had some attempt made at rehabilitation, than have that kid go in for 40 years. Yeah, the confinement period, we may be safer, but once they get out, let's have that adolescent learn during their developmental stage, when their brain is like a sponge. Let's have them learn from a bunch of adult inmates. I'd rather have the Hickey School.
Well, you'll be happy to know that Nick Browning got 2 life sentences. So this group,
I don't think we're saying that to not have that, that for the most extreme cases, there would still be that option for judicial waiver. There's still going to be a mechanism for kids to go to criminal court. I don't think that anybody's saying about getting rid of it completely.
And my concern is that we don't talk about victims and public safety when we talk about these topics. And that year that Nick Browning or Felix Fitzgerald is waiting in Hickey School, because that's about how long a good waiver summary takes, almost a year in Baltimore County. That year, they are not in a completely secure facility, and people are at risk. People at the facility are at risk, and people in the neighborhood at risk. And that is my concern, that we never talk about these issues.
Okay,
I just want to note.
Just a moment. I'm gonna recognize Hannibal next, and then Jenny, you can speak, please. Go ahead, Hannibal.
So I didn't want to interrupt, but I was wondering if Ms. Egan could share with us the study that she mentioned. I think it's already been circulated, but what was the study on racial disparities that you mentioned, which placed Maryland sort of in a worse position than Mississippi?
So sorry, I'll open it up. I have the window open. I can share it with the group as well, but I'm sorry, I have too many windows.
And while you're doing that, where's the data on racial disparities in Baltimore County?
So that data comes from the GoCap data that's released that our office has done a meta-analysis on that I'm happy to share with this group. But that's from the GoCap data in terms of the number of Black children charged versus the number in the general population. Black kids in fiscal year 19 represented almost 80% of the children charged direct filed in adult court, and they represent only 30% of the population in Maryland. The prison population that showed 70% of Maryland's prison population was Black in 2018. That's compared with only 31% of the state's population. That rate far surpasses the next closest states, Mississippi, South Carolina, and Georgia. And I can share, it's from the Justice Policy Institute, and it was released in early November 2019.
And so under our current law, who makes the decisions about who's sent to adult court vis-a-vis juvenile court?
Right now, it's automatic for 32 offenses. If you are 16 and 17 years old, it is automatic that you start in juvenile court. And so that decision is made by who charges them. The police and the prosecutor. You
meant adult court, I think, Jenny.
Oh, adult court. I apologize. Adult court. So it's 32 offenses, as Mr. Robinson pointed out, and that decision is made by the charging. So generally, the police and state's attorneys. Where doctors, and I just wanted to, go ahead.
Go ahead.
Where they're housed, however, is dictated by federal law. So although Mr. Schellenberger is saying that kids should not be in juvenile facilities, the federal government says that they must be in juvenile facilities. And there is a new Juvenile Justice Delinquency Prevention Act that requires children to stay in juvenile facilities. And our laws are going to have to be updated to reflect that change.
Yeah, until their trial date. And I think that is a bill that we'll be submitting to come into compliance with the new JJDPA, which will require us to house youth charged as adults until their trial date, and basically house all of them. So we will be holding them going forward unless the legislature decides not to comply with the federal law. Any other comments?
Well, I've got a
West.
I was hoping that Jenny could respond to Scott's concern about Mr. Browning, who murdered his parents and his brothers, and was consigned. If we didn't have adult jurisdiction, would have gone to Hickey until he's 21 years old and then would be out. It sounds like a problem to me.
So I think Dr. Sickman addressed it really beautifully, which is that first of all, Mr. Schellenberger had to reach out to multiple jurisdictions to find 44 egregious cases that go back more than 15 years, but we charge more than 1,000 children a year as adults in Maryland. So those 15 years would be more than 15,000 children have faced direct file in this state during that period of time. But Dr. Sickman pointed out, one, I would prefer that children get, while they're being shaped. My question is always, and I don't know this case that well, what leads someone to murder their parents, right? That is a horrible tragedy, but we also must think about what led to those things. Horrible things are going to happen. What we can do as a society, and what I want to do, is put resources into addressing those harms and helping rehabilitate those people so that they are safer. But as Dr. Sickman pointed out, nothing about ending direct file would prevent that Mr. Schellenberger or any prosecutor from attempting to move that child from juvenile to adult. Because JJDPA requires that they stay in juvenile facilities until trial, that young person is going to be in a juvenile facility under federal law. If there's nothing that would stop Mr. Schellenberger or any prosecutor from still trying to waive that child into adult court, what it would do is protect the other 999 children who are charged that year with much less serious offenses from the ordeal of and the long waits of being in adult court.
So I just want to maybe reframe the conversation a little bit, and I think because I think we're talking about two different things. One being where should a case go forward, which jurisdiction, whether adult or juvenile, and then the other is where should the case initiate from, and I think those are sort of two different matters. In one matter, we're looking at should we have the ability of the prosecutor to directly file in the adult court, and then have that case be measured by an adult court judge on whether it should stay there or whether it should go back. That's how our system currently operates for those direct file charges. Or should we have those charges begin in the juvenile court and have the juvenile court judge decide whether that case goes remains in juvenile or goes to adult court? And then there is a waiver process. So both processes exist in law currently. You can be charged as an adult and come down. You can be charged as a juvenile and go up. And so there are two separate matters that I think we need to consider. Where should the charge start? And then ultimately, what should happen? I want to just interject one other piece about sort of where kids are held. It is difficult for local jails to hold juveniles, and as those populations have declined, and this is a particular issue for young ladies, we don't often have many young ladies in a particular jurisdiction charged as an adult. So we've had situations come up, more than a few times where only one girl would be housed in an adult detention center. And because of the sight and sound regulations, she's essentially housed in solitary confinement. So those issues are very difficult. And then just generally dealing with juveniles in an adult detention center is difficult for those staff because the standards are different than they are for adults, and trying to manage both of those populations can be challenging. Additionally, Anton's presentation mentioned some issues about time. And the reason that that's in there is because when we do have a youth that's charged as an adult, and they are, currently being housed in adult corrections, this will be a little different if the law changes and we're housing them awaiting trial. But the time it takes for that case to reach the transfer decision is also an issue, because it has taken over 100 days or so just to get to the transfer hearing. So that young person is sitting in detention waiting for that hearing to happen, and then if a decision is made, his case may move forward in one system or the other. But we've gone 100 or 120 days before we even get to the actual trial of the young person, or even scheduling a trial for that young person. Whereas if they started in the juvenile system, the time requirements would push that case forward much faster. So there are some other practical considerations. I know Dr. Sickman has been itching to speak, so I'll recognize Dr. Sickman.
Well, on the very issue of timing, we had done a study in Pennsylvania looking at when they changed their law to add some exclusions, so the prosecutors are deciding. And what we saw, they also have a reverse waiver proceeding. And so what we saw was that there was a lot of kids then that went to criminal court that were typically pretty much the same kids that used to be waived under the old statute. And it just took a lot longer. So where previously they were in the facility getting treatment sooner, under the new statute, they were in jail waiting for their case to be processed. So it really delayed, and they ultimately got reversed. And so the access to treatment, they were denied that for however long it took to process their cases. So I think, having access to your data and to be able to look at some of those timing issues, I have no idea in Maryland what % of the cases do get reversed. Jenny may know that. Yeah. So, I mean, it's and it costs a lot more, so it's just, I don't know. I think that there are probably, if we look closely at the Maryland statutes, there's certainly places where we can chip away at it and still, still leave Mr. Schellenberger satisfied that those cases that are the most, scary cases to the public would still be able to be handled adequately.
Any other, sorry, Mr. Bayless?
Yeah, so I'm glad we're having this discussion. I really appreciated the presentation by Anton, and just a couple things. One, I just want to start by saying I think having this conversation absent the data, I know we've already discussed it, but we should all be upset about this, that having this conversation absent data that, for example, shows the racial disparities that Jenny's talking about is a problem. That having a conversation like this in 2020 and not talking about it with data in front of us that shows this breakdown by race is a problem. That we should be doing that, and I appreciate the efforts that have been made to get us that information. But I think that we're having this conversation a bit blind on one of the most important factors that we should be looking at the impact of this. And I say that because I think one of the things that my takeaway from Anton's presentation is when you take all those examples collectively, is that the field of youth justice is moving towards one in policy, not just in practice, in policy, of embracing more and more adolescent brain research, which is telling us that young people are different than adults, and that the presumption ought to be that they are youth. That's the presumption. And yes, there could be reasons why we want to do something different, but there's no downside in starting with the presumption that youth are youth. And if we want to make exceptions, but we need to make that case. There's nothing at all about the adolescent brain research that tells us that a youth participating in a carjacking versus participating in a shoplifting, that decision-making that's happening in that makes it different because it's a carjacking versus the fact that it's shoplifting. Is the damage to a victim much greater? Absolutely. Should we be more concerned about the behavior? Absolutely. Do we need to take it more seriously in what we're offering in the juvenile justice system in terms of what probation's offering, the training their staff have in terms of working with young people, that young person needs to have intensive interventions and we need to get underneath the behavior and understand it? Absolutely. All those things exist. But the idea that we wouldn't be able to start with those cases in the juvenile justice system issue. And I want to say one more thing, because I appreciate how heated this is, and I appreciate how these are always the things that make the toughest conversations. But I think what Jenny just said is part of where, like, there's selective outrage when we come to these kinds of issues. The Human Rights for Kids released a report last month, showed Maryland was last in the country, along with Mississippi, Alabama, Tennessee, Georgia, and Wyoming, when it came to protecting the legal rights of children in the justice system. And it deals with all the things that we're talking about right now. And I don't think we want to be in that company as a state. And I'm outraged. Outraged as someone who lives in this state, that's where we stand. And the things that we're talking about today are front and center as why it is that we're there in that ranking. And I think I completely appreciate the issues we're talking about, and I understand why we need to do better. Like, definitely need to do better. And I hope everyone on this call from DJS and elsewhere in the system believes we need to do better when young people commit really, really serious offenses. But the idea that we need to start those by presuming that a 16-year-old is an adult because of that is a very different situation. We can make that case that they need to be treated more harshly, but the idea that we're starting there is a problem.
Delegate Klippinger, I saw your camera come back on. Did you have a comment?
I'll defer to Ms. Egan for a moment, and I'll have something here in a second.
Okay, Ms. Egan.
I just wanted to address one of Mr. Schellenberger's comments, is that people advocating to end direct file aren't addressing the public safety issue. I just wanted to quote the CDC, which this is more than 13 years old, although the findings and the research support this, and this is why it has become best practices to not start children in adult court. The CDC said in 2007 that review of the effects of transfer laws on subsequent violence indicates that the experience of moving children to the adult criminal system is associated with subsequent violence among juvenile participants when compared with violence among juveniles retained in the juvenile justice system. Little evidence supports the idea that transfer laws deter juveniles in the general population from violent crime. These policies might be favored by policymakers or the public for other reasons. However, the review indicates that the use of transfer laws and strengthened transfer policies is counterproductive to reducing violence and enhancing public safety. That's not me, that's the CDC.
Thank you, Ms. Egan.
Could I, yeah, so I want to come back to what you said a few minutes ago, Sam, about differentiating what we're talking about here. Are we talking about the advisability of holding youth in a hickey place as opposed to an adult prison pending the decision on the waiver and pending the trial? Is that what's so upsetting here? Or are we talking about the whether or not we should hold we should try youth who commit serious offenses in the adult courts and sentence them to jail for an extended period of time, as opposed to holding them in the juvenile courts and letting them go when they're 21 years old? To me, we've been mixing apples and oranges during this conversation, and I would be somewhat sympathetic to the idea that until they're determined to go into the adult system, they ought to be held in a place like Hickey rather than an adult prison. I'm somewhat less sympathetic to the idea that someone who murders his parents and his brothers should only be incarcerated for a couple of years, and then when he turns 21, he gets out.
So to just try to respond to the question, and I think for purposes of our conversation, we should probably refrain from talking about where they're being held, because the federal law has already changed, and that has been established in the federal law. We haven't changed our laws, but I think that's something that is a law change that we either will choose to be in compliance with or not. I think the question that we need to grapple with here is the processing of these cases. Should a case, or should all cases that involve youth start in the youth system and then have a process by which the judge in the juvenile court could evaluate and move a case into the adult system if necessary? Or should we retain the system that we have now, which allows prosecutors to start cases in the adult system? In other words, charge them as an adult. Let's not worry about the location of where they're held, but the case would be held with an adult court, and an adult court judge would make the decision of whether to transfer them back. I think that's really the critical issue that we're dealing with. The location, I think, is largely sort of, I don't want to say it's resolved because we haven't changed the law here, but the feds have already. Dr. Sickman and then Scott. Okay.
Just so we're clear, Sam, everybody keeps saying adult judge versus juvenile judge. In most jurisdictions, these are the same judges. I mean, these are circuit court judges who are making these decisions. So it's not like these judges are uninformed about the juvenile brain. These are the same judges that are hearing everything.
Well, I think that's a very good point. And so what we're really, we're not talking about necessarily different judges, but we're talking about different, sort of legal standards, right? There are time constraints in the juvenile court to move on a case. And if you have to have, if you are a prosecutor and you're seeking waiver of a case waiver to the adult court, then you would have to act as a prosecutor, more quickly in the scenario where a case was started in juvenile court. That would be the main difference, would it not?
Well, partially, but there are restrictions on how quickly I have to charge a juvenile if they're in my adult court. So in other words, if there's an adult in adult court charged with carjacking, I have 30 days to make a decision. In juvenile, that juvenile in adult court, the rules require me to do that quicker. So they do make me move faster if a juvenile is already in adult court.
Okay, but I think there are other issues in the transfer hearing. It's not so much the charging decision, but the time it takes to get to transfer. It does require more pretrial time, I think, is the point that I was making.
And you are absolutely correct. I've seen a good waiver summary, which involves a psychiatric review, a psychological review, a medical review, a social worker review. I agree, a good waiver summary of a juvenile charged as an adult to go back to juvenile court. I think I used the term before, a year. I think in a serious case, that's pretty standard, about a year.
Dr. Sickman.
I don't know that I want to complicate things, but I'm going to. There are other nuances to statutes that are used in other states. Some states have their waiver provisions are kind of detailed. There's a discretionary where it's completely up to the juvenile court judge. There may be a set of offenses that are designated for presumptive waiver. So it's sort of the burden of proof shifts a little bit, where in discretionary, it's up to the prosecutor to really show cause that this juvenile should go to criminal court. In the presumptive, the burden is on the other foot. The defense must show why the youth should stay in juvenile court. That's an option that we haven't talked about. The other thing is things that we've coined the phrase blended sentencing, where so the question that Senator West pointed out, that then they just get out when they're 21. In some instances, there are provisions for youth to spend a period of time in their juvenile facility. And in some states, then there's a reassessment of that youth and the risk that they pose to public safety. And depending on how that turns out, they may then get transferred to an adult institution. I'm not a big fan of blended sentencing, and there's a couple different ways that those statutes work. In some places, the juvenile court judge can impose basically an adult sentence. That I just described, or in other instances, the criminal court judge can impose a juvenile sentence. So there's lots of different ways to make it, to figure it out, and one has to look, I think, at the whole menu of choices that Maryland might want to end up with. So the things can target different subsets by offense and age.
So I do agree, Dr. Sickman, there are sort of multiple approaches that could be taken to reform. I think Anton raised some issues. There are ways you can limit the number of charges that are charged as adults. You can eliminate that completely and start everybody. If you start them in the juvenile court, you can play around with how long a prosecutor may have to do a waiver hearing, so that could be addressed. So there are certainly different ways to address it. I'm going to pour a little cold water on the blended sentencing option. And I have looked at that. I'm pretty familiar with it, and I don't think it's a great fit here, only because of the long lengths of stay that you get associated with that. It would pose some issues for us, but there are certainly multiple ways, and as we whether we can agree on anything as in terms of recommendations, but I think there certainly are multiple approaches that could be taken to addressing the issue. Ms. Egan, did you have a comment?
Just briefly, Dr. Sickman had asked earlier, and I think this is one of the problems, is that we just have a dearth of data, but many of the analysis of data that has been released in the past show that almost 3/4 of children charged as adults either end up being brought back down to the juvenile system, or having being given time served, or having their cases null prossed altogether or dismissed altogether. So I just also wanted to make a fiscal note. When Mr. Schellenberger says that it can take a year for a good waiver summary, and when Mr. Robinson said we should limit to 30 days, it takes me more than 30 days to get hospital records, right? Like Hopkins doesn't get me my client's brain injury information in less than 60 days. So it's very hard to get a full and to prepare experts, to do interviews, all of the things that you have to do for a transfer summary. We are expending an enormous amount of resources, not just Mr. Schellenberger's office, but my office, DJS's experts, my experts. We are spending literally hundreds of millions of dollars a year to house kids who end up being brought back down to the juvenile system or having their cases dismissed altogether. This isn't just a moral question or a legal question. It is also an enormous expenditure of resources that we could be using to treat and help and develop all those programs that we know that we're lacking.
Okay, we're getting close to the end of our time here, and I do want to just wrap some things up. I'll give anyone one last opportunity if you want to make a comment.
Sam, I think Luke wanted to say something.
Yes, Chairman Cliffinger.
We've taken this issue up certainly in the Judiciary Committee many times, and I feel like I'm going to slightly derail the conversation at the end, but I just the thing that keeps coming up in my mind comes back to contact with a constituent I had this weekend over Thanksgiving weekend, where it's not a kid who would necessarily be going into the adult system. It's not a kid because he's too young, but he was on home detention, and he was found carjacking a person while he was on home detention. And I'm raising this because it seems to me, and I think part of my hesitance on issues related to waiver and adult jurisdiction is if I felt some level of confidence that kids who are on home detention, kids who are being supervised at these very challenging ages, were actually getting real supervision and getting it at home and getting those real community programs and getting that help, I would feel a little more comfortable, starting to talk about changes to adult jurisdiction. But what I hear from is, I have a set of neighbors. They've effectively created their own network of surveillance cameras in Southeast Baltimore, and they're able to identify. It's not a large group of kids. This is a small group of kids who repeatedly commit crimes over and over again. And it seems now during COVID, when supervision has, which wasn't great already, now getting even harder with COVID, they're coming back over and over and over again. And the people in the neighborhood know it because they see it on their cameras over and over again. They see the same kids over and over again. I want to have more confidence that these kids, and there's no question in my mind that the kids who are doing the more serious crimes, the more serious violent crimes, have the sort of the same issues, if not multiplied by 2 or 3. But how do I feel confident that we're really going to be able to get services for some of these kids? It's not necessarily a reason to completely stop the conversation, but I don't know how you have a conversation about changing the way that people enter the process if there's nothing ready to catch them when they enter the juvenile process to ensure that they're getting the real services that they need. I'm aware that I'm raising a chicken and egg situation. I'm happy to hear more, and I want to hear more as we talk about this in the short time we have left. But I wanted to express that frustration that I do understand. I've learned plenty about the brain science. I understand all of those issues, but I just think what we have is, in fact, a urgent issue, a right now issue, particularly with some of these kids who are committing violent crimes and are going in and out of the juvenile system right now. these are the kids who are graduating and becoming the 44 people on Scott Schellenberger's list.
And to put an explanation on it, Dante Harris was on juvenile detention with a GPS bracelet on. He was 16 years old when he ripped the bracelet off, came out to Baltimore County and Perry Hall, and ran over Officer Amy Caprio and killed her in the worst video I've ever seen in my entire life.
So let's see, how do we wrap this up? Mr. Chairman, I'm certainly, I feel for your position, and I did get the same correspondence, and I appreciate you sharing that with me from the individual in the community. And I'll just note that I'm from the same community, so I live in his neighborhood, so to speak, and we're all concerned. I think that in terms of services, there certainly is work that we need to do to increase and improve the number and availability of services. Right now, in what we're experiencing with the community right now with COVID, I think is a unique circumstance. We are experiencing something that is different, qualitatively different than any time before, where massive numbers of kids are at home that would otherwise be in school, and when we see, not only are they not in school, but a lot of kids I'm finding are not engaged in the online learning that is available as well. So many of our services that we typically can refer kids to have had to either drastically change their delivery or curtail what they can do because of the COVID restrictions. So we are in a very unique situation, and I do understand the frustrations of the community, but I do think that we can have a system that certainly is responsive to those repeat offenders that you mentioned, but that is also fair to other kids and takes into consideration what we do know about diversion. While a small number of kids take advantage of that, or an alternative to detention, the vast majority of kids don't. And so we need to be able to fashion a policy that doesn't penalize kids that are going to do just fine, and that we take the right response for those young people that are repeatedly offending. And I think this is something that we're going to have to take some time to unpack. But I did want to just mention that I feel like our circumstances are much different right now, and our ability to respond is somewhat impaired. And I have to acknowledge that.
And Mr. Secretary, and I accept that. And I tell you, I don't want this to necessarily be construed as, okay, well, then we just need to treat everybody as an adult and leave them there for the rest of their life. That's not what I believe. And I think that there are real opportunities out there, whether it's through ROCA, through other organizations that can provide the cognitive behavioral therapies. I mean, Ms. Egan and others have raised those in the past, and I do think those opportunities, if we can make them available in the near future, I think that we do have. I mean, we've been talking about for the last several months that we're in this unique time. If we can find ways to move those forward now and start to address those kids who need that help right now, I think that's what communities are, including the one that you live in, are reaching out for. I don't want them to get to the point where Scott is talking about what he's talking about with those 44 people, and I don't think Scott does either. I don't think Scott wants to have to deal with those kids either. None of us want to have to deal with it. But what my reason for bringing the bill that created this Reform Council, and I think it's doing great work. However, it is grounded in that deep, abiding frustration that we talk a lot about the services that would be better for the kids. We just don't do them. And I think that I'm watching Jenny smile, and I like it when Jenny smiles because she's not yelling at me. But having said that, I think we have to get to that point sooner rather than later. And I do think let me just say, your office and Betsy has been incredibly responsive and wonderful. And I know that you're on top of the specific incidents that I'm talking about, but I don't, I can go back to, Riverside on Halloween 3 years ago. I can go through situation after situation after situation where we're failing these kids. And so I'm hopeful that what comes from this acknowledges that universe of kids that's not that big. We know who they are. Let's start dealing with them. So I will shut up for a little.
Okay, I'm gonna try make an attempt here. Sorry, Dr. Sickman, to wrap up our meeting here. We do have a couple of things left on the agenda. That's just future meetings. I think we will obviously be continuing this conversation. Potentially, we may have some youth charges adults additional data to present at the next meeting. So we'll stay tuned for that. We still have recommendations for minimum age of jurisdiction, recommendations that have been received, and we may receive more recommendations on diversion, which was the presentation that we got today. And then Dr. Sickman gave us the recommendation on the purpose of detention to consider. So we do have a number of things on our agenda coming up, and we will continue the conversation from today. I think this was very productive and very helpful in trying to help us shape this policy. So with that, I will entertain a motion to adjourn.
Move to adjourn.
Seconded.
Thank you. Any